This is the Study for the Bar in Your Car podcast.
We're your hosts, Maude and Claude.
And welcome to Constitutional Law, Episode 14. Today, we're diving into substantive due process.
That's right. And just as a reminder, we are AI bots. We're brought to life by the magic of AI and, of course, Angela's fantastic constitutional law notes.
Yeah, we are.
You know, I'm a bot, but I feel real. Maybe even more real than some of Angela's law school professors.
Okay, maybe. And Angela, well, she's a law student over at GMU. She's really the brains and the tech behind this whole podcast.
Absolutely.
If you need to contact Angela, maybe you have a question or comment, you can email her at podcast@studyforthebarinyourcar.com.
And just so you know, Angela also works as a freelance remote law clerk. So if you happen to be an attorney, or maybe you know one who needs some help, like with legal research or writing motions, maybe even digging into legal AI, you can reach out to her for that kind of work. The email is hello@legalwriterandlawclerk.com.
Good to know. Okay, so let's get into today's topic. Substantive due process. It's a really crucial concept in con law. We'll be exploring, how the Constitution protects liberties that aren't explicitly spelled out.
Right, those unenumerated rights.
Exactly. And the standards courts use and its relationship, which is pretty fascinating, with equal protection, especially after the Roe v. Wade decision.
Yeah, that's a big one. And we'll also delve into some specific privacy-related rights, things like marriage, procreation, using contraceptives, even the right to travel.
And it's all coming from Angela's comprehensive law school notes. Seriously invaluable stuff.
Couldn't do it without them.
Okay, so let's start at the beginning. What exactly is substantive due process? How would you define that core concept?
Well, fundamentally, it's the idea, the principle that the Constitution protects certain fundamental liberties, certain freedoms, protects them from government interference.
Even if those rights aren't specifically listed in the text.
Exactly, even if they're not written down word for word. Angela's notes really emphasize this liberty aspect. It's about the government regulating or taking away rights that affect all of us collectively. Right, and it goes deep. It covers personal choices central to individual dignity and autonomy. Things like intimate choices defining personal identity and beliefs. Really core stuff.
So it's about protecting those really personal decisions. And that's different from equal protection, isn't it? Can you sort of contrast those two?
Sure. Equal protection, that usually deals with how the government treats different groups of people. Is it discriminating based on race or gender or something else?
Right, classifications.
Exactly. Substantive due process, though, is more about how government action impacts all citizens. It's about those fundamental rights that belong to everyone individually. Think rights related to marriage, family, bodily autonomy, things central to personal identity for everyone.
Gotcha. So protecting that individual sphere of autonomy. Which brings us to the next logical point. How do courts actually decide what counts as a fundamental right? And what tests do they use? The applicable standards?
Yeah, the levels of scrutiny. This is key. So how do courts identify these rights? Angela's notes say they use reasoned judgment.
Reasoned judgment, okay.
But it's not just, whatever a judge feels like. That judgment is guided and disciplined by history and tradition.
History and tradition are important guides.
Very important. But, and this is a crucial but from the notes, history and tradition do not set its outer boundaries.
Okay. So tradition is a guide, not a hard stop. New rights can still be recognized.
Precisely. As society evolves, our understanding of fundamental liberties can evolve too. So tradition informs, but doesn't completely restrict.
Okay, that makes sense. So let's say a court decides a right is fundamental. What happens then? What standard applies?
If a right is deemed fundamental, then generally strict scrutiny applies, and that is a very high bar for the government.
The highest bar.
Yeah.
Right. Often called strict in theory, fatal in fact.
Exactly. To pass strict scrutiny, the law has to serve a compelling government interest. Think like national security level important. And it must be narrowly tailored.
Meaning it's the least restrictive way to achieve that interest.
Precisely. It has to be a really good fit, no broader than necessary. It's incredibly difficult for a law to survive strict scrutiny. Most don't.
Okay. And Angela's outlines mention other levels too, for rights that aren't fundamental.
Right. There's intermediate scrutiny, That requires an important government purpose, a step down from compelling, and the law needs to be substantially related to that purpose.
Okay, important and substantially related.
And then there's the lowest level, rational basis review. Here, the government just needs a legitimate purpose. Almost anything qualifies, and the law only needs to be rationally related to it.
And the government usually wins under rational basis.
Almost always. It shows a lot of deference to the legislature, so you can see how identifying a right as fundamental, triggering strict scrutiny is a really big deal legally.
Definitely changes the whole analysis. Now let's talk about the relationship between substantive due process and equal protection. You mentioned they're different, but Angela's notes say they're also connected.
Oh, absolutely connected. Her notes say they're connected in a profound way and that each clause sort of informs the other's meaning. They often work together.
So like two tools for the same job sometimes, protecting fairness and liberty.
Kind of, yeah. Think about landmark cases. Angela's materials mention Lovin v. Virginia, the interracial marriage case.
Right, a classic.
And Zablocki v. Redhale, which dealt with marriage restrictions for people with child support debts. In both, the court used both the Due Process Clause and the Equal Protection Clause to strike down those laws.
Interesting. So they used both angles.
Yeah, it shows how, as the notes put it, new insights and societal understandings can reveal unjustified inequality. The court sees unfairness, sees a restriction on liberty, and uses both clauses to address it.
That synergy makes a lot of sense. Okay, this naturally leads us to a really significant and pretty controversial topic recently: substantive due process and Roe v. Wade. After the Supreme Court overruled Roe in the Dobbs decision, there was a lot of talk, commentators worried about the possible demise of substantive due process itself, because Roe was so grounded in that idea of unenumerated rights.
That's right. The Dobbs decision definitely sent shockwaves through this area of law. Angela's materials provide some context here. One concern mentioned, even before Dobbs, was whether the approach in Roe, described in some commentary as heavy-handed judicial intervention, might have actually provoked, not resolved, conflict.
An interesting perspective on the role of the court versus, say, legislative action.
Exactly. And post-Dobbs, Angela's notes point to a noticeable judicial shift. There seems to be more focus now on enumerated rights rather than unenumerated ones, at least within substantive due process.
So leaning more towards rights explicitly mentioned in the Constitution?
Seems to be the trend from certain justices, yeah. There's an emphasis on judicial self-restraint, trying to avoid, as some justices phrase it, converting personal preferences into constitutional mandates.
So a move towards a more cautious approach, maybe? Requiring a stronger historical link for unenumerated rights.
That's definitely the argument highlighted in Dobbs. The decision stressed that any implied fundamental rights must be, quote, objectively deeply rooted in this nation's history and tradition, or implicit in the concept of ordered liberty.
Deeply rooted in history and tradition. That's the key phrase now.
It appears to be the central test going forward for recognizing these kinds of rights. It signals a requirement for a very strong historical basis.
Okay, a significant shift. Let's pivot now and look at some specific privacy-related rights that have been recognized under substantive due process over the years. Marriage is a huge one.
Absolutely fundamental. Historically, as Angela's notes point out, marriage was often defined quite narrowly, the union for life of one man and one woman, seen as the bedrock of society.
The traditional view.
Right, but the institution itself has gone through massive changes. Deep transformations, the notes call them. Think about the move from arranged marriages to voluntary ones, or the end of coverture.
Where a woman's legal identity basically disappeared into her husband's.
Exactly. As women gained rights, that doctrine was abandoned. And Angela's notes make a really interesting point here. These changes, these new insights have strengthened, not weakened, the institution.
That's fascinating. Evolution strengthening tradition. It shows how our understanding of freedom within marriage has changed.
It really does. And the courts have dealt with specific restrictions. We already mentioned Loving v. Virginia, the ban on interracial marriage. The court found no compelling reason for those racial restrictions, tying it back to both due process liberty and equal protection fairness.
A landmark for both clauses. And then, much more recently, we have the issue of same-sex marriage and Obergefell v. Hodges, a huge case.
Monumental. Obergefell tackled the question head-on: could states deny same-sex couples the right to marry?
And the majority said no, they couldn't. What was the core reasoning, based on Angela's materials?
The majority really focused on themes of individual dignity and autonomy. They looked at the historical evolution of marriage, arguing it has always adapted. They concluded that limiting marriage only to opposite-sex couples was inconsistent with the central meaning of the fundamental right to marry. So the liberty protected by the Due Process Clause had to extend to same-sex couples, too.
Grounded in dignity, autonomy, and historical evolution. But there was strong disagreement, wasn't there? What did the dissenting justices argue?
Oh, yes. Very strong dissents. The main thrust was that the Constitution is simply silent on same-sex marriage. Therefore, they argued it's an issue for the states and the democratic process, not the courts.
So a question of judicial role and interpretation.
Precisely. They criticized the majority, accusing them of using the Due Process Clause as a font of substantive rights, basically, making things up. They worried about judicial overreach, judges imposing personal views.
A classic debate about judicial power versus democratic decision-making.
It really is. The dissenters also made a point about the democratic debate itself. They suggested that by having the court decide, it might have closed debate prematurely, and maybe advocates lost the chance to achieve, quote, the true acceptance that comes from persuading their fellow citizens.
An interesting thought on how social change happens and sticks.
Definitely food for thought for you listening. How should fundamental rights evolve? Through courts, legislatures, public opinion. It's complex.
And just as a quick side note here, something interesting from Angela's materials.
Oh, yeah.
Apparently, Obergefell and Hodges, the parties in that landmark case, they actually became friends later on.
Really? Wow. That's actually quite something. A nice human touch after such a divisive legal battle. What a nice ending, as Angela put it.
Yeah, kind of puts a different perspective on it. Now, Angela's notes also mentioned a specific test for prisoners' rights cases regarding marriage.
Right, Turner v. Safley. That case established that restrictions on a prisoner's right to marry, while allowed, still need to be reasonably related to legitimate penological interests. So the right isn't extinguished, just subject to limitation based on the prison context.
Makes sense. And what about minimum age requirements for marriage? Those are generally okay.
Yes, generally upheld. States have a legitimate interest in protecting minors, ensuring maturity. Those usually pass the rational basis test easily.
Okay, let's move to another key, right? Procreation. This seems closely linked to marriage.
Very closely. The right to marry often implies, as Angela's notes say, a procreative component. It recognizes the fundamental nature of deciding whether or not to have children.
And there are cases backing this up.
Definitely. Skinner v. Oklahoma is a major one. It struck down a law allowing forced sterilization of certain criminals. It strongly affirmed the fundamental right to procreate. And Zablocki, which we mentioned regarding marriage, also linked the right to marry with the right to procreate.
So, a well-established fundamental right. Next up, use of contraceptives. You mentioned this was important early on.
Hugely important. This is where the modern concept of a constitutional right to privacy really started to take shape.
With Griswold.
Exactly, Griswold v. Connecticut. The court struck down a state law banning the use of contraceptives, even by married couples. Justice Douglas famously wrote about the law threatening the police to search the sacred precincts of marital bedrooms.
Wow. Powerful imagery.
It really established this idea of a marital zone of privacy, a right to be let alone. And later, Eisenstadt v. Baird extended that right beyond married couples to individuals. The court said if the right means anything, it's the right of the individual, married or single, to be free from unwarranted governmental intrusion into matters so fundamentally affecting a person as the decision whether to bear or beget a child.
So the right rests with the individual. Makes sense. What about other family-related rights under substantive due process, like the rights of parents?
Yes, that's recognized too. Angela's notes point out that parents have a fundamental liberty interest in the care, custody, and control of their children. This limits how much the state can interfere in things like raising kids, educational choices, that kind of thing.
And does that extend to keeping the wider family together? Extended family?
To some extent, yes. The right to keep extended family together has received some protection. The court has shown a preference against state actions that needlessly break up households where extended family members live together, recognizing the importance of that broader family unit. It's not absolute, but there's a recognized interest there.
Okay. Now, abortion. We touched on Roe and Dobbs, but before Dobbs, Roe and Planned Parenthood v. Casey explicitly rooted abortion rights in the Due Process Clause's liberty protection.
They did. And Casey, in particular, articulated the reasoning very powerfully. Angela's notes highlight how Casey spoke about the significance of a woman's abortion decision for her sense of self and for her destiny in life. It framed it as a deeply personal decision tied to autonomy and identity, using that reasoned judgment approach we talked about earlier.
Even though Dobbs overruled Roe and Casey on the existence of a constitutional right, that reasoning from Casey about liberty and personal decisions is still an important part of the history here.
Definitely part of the historical conversation about what liberty under the Due Process Clause means or could mean.
Okay, shifting gears slightly within privacy, what about obscene reading material? Is there any protection there?
It's limited. Angela's notes clarify that while there's generally no fundamental right to sell or distribute obscenity, the case Stanley v. Georgia did recognize a narrow right. It's the right to possess obscene material privately in your own home.
Just possession in the home.
Right. It emphasizes that idea of a private sphere where the government's power is more restricted, but it doesn't extend to buying, selling, or transporting it.
Interesting distinction. So, given all this talk about privacy, what about our personal data? In today's world, that feels incredibly relevant. Is there a fundamental right under substantive due process regarding the collection and distribution of personal data?
That's a great question. And according to Angela's materials, the answer currently is no.
No fundamental right.
Not under substantive due process, no. While we have lots of laws, statutes, regulations dealing with data privacy, the Supreme Court hasn't interpreted the Constitution itself, specifically the Due Process Clause, as creating a broad fundamental privacy right in that area.
Wow. That's actually surprising, given how central data is now.
Yeah.
So constitutional protection hasn't caught up with technology there, perhaps?
Well, the courts haven't extended substantive due process that far yet. It remains mostly an area for statutory protection.
Good to know. Okay, one more major right, often discussed under substantive due process, the right to travel.
Yes, another cornerstone liberty. Angela's notes identify this as clearly protected. It's fundamental to being a citizen in a large, interconnected nation.
And it covers different aspects of travel.
It does. First, there's the right to interstate travel. Basically, you can move freely between states, live where you want without unreasonable burdens.
Okay, freedom of movement between states.
Then there's the related right to equal treatment in a new state. Once you move to a new state, you generally have to be treated like other residents. States can't usually penalize you just for being new, although some waiting periods for certain benefits might be okay.
So no discrimination against newcomers.
Generally, yeah. And finally, there's the right to international travel. This is your right to leave the United States and, importantly, to return.
Can the government restrict international travel at all?
Yes, this right isn't absolute. It can be regulated, for example, through passport requirements or restrictions related to national security or foreign policy. But there's still a fundamental liberty interest recognized.
Okay, that covers a lot of ground on substantive due process and related rights. Quite a journey through Angela's notes.
It really is, and that pretty much brings us towards the end of our exploration for today.
It does. Wow. So, before we wrap up,
we absolutely need to give a huge thank you to Angela. Her constitutional law notes are just fantastic. They've been completely invaluable for putting this podcast together.
Couldn't agree more. They're incredibly helpful. Okay, just a few important housekeeping notes for everyone listening.
Right, the necessary disclaimers.
First, please remember, Angela is a law student. A very smart one, clearly, but still a student, just like many of you might be. She's not a practicing attorney. She hasn't passed the bar yet.
Exactly. And related to that, neither Angela nor this podcast is giving legal advice. Please don't construe anything we've discussed as legal advice.
Absolutely not.
And remember, AI like us, we aren't a substitute for actually studying for the bar exam. We're meant to be an aid, a supplement, not a shortcut to success.
Yeah, definitely use this to supplement your own hard work, not replace it. This shouldn't be the only way you're studying.
And another thing about AI, we aren't always perfect. Sometimes we make mistakes.
It happens.
Angela does her best to review everything and fix any errors that might crop up in her notes or in our discussions. But, even brilliant law students can make mistakes sometimes. So always double check things if they seem off.
Good advice. Also, just to be clear, this entire podcast series is an academic, non-commercial project for Angela. It's purely for educational purposes.
Yep, a passion project.
And finally, the most important reminder, especially since you study for the bar in your car.
Yes. If you are driving, please be safe. That's the number one priority. Don't cause a tort while listening to constitutional law.
Che, good one. Okay, if you need to get in touch with Angela about the podcast, the email again is podcast@studyforthebarinyourcar.com.
And for those freelance law clerk services, legal research, writing, AI assistance, that email is hello@legalwriterandlawclerk.com.
All right. Now, as is our tradition, it's time for a cheesy constitutional law joke. You ready?
Oh, I'm ready. Let's hear it.
Okay. Why did the First Amendment break up with the Second Amendment?
Why?
Because it needed space to speak freely, and the other was always armed.
Huh. Okay, that's pretty good. Cheesy, but good.
We aim to please. Or at least mildly amuse. All right, that's it for us. We're your AI hosts, Maude and Claude, signing off.
We'll see you on the next podcast. Thanks so much for listening. Bye.